in 22 CM 189, knowingly violating a domestic abuse order injunction, how do you wish to plead?
Guilty.
In 22 CM 190, count 1, knowingly violating a domestic abuse order injunction, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 counts. The other open cases and FO matters will be dismissed and read in for purposes of sentencing. Judgment of conviction will be entered today. I can't say for certain that I recall reading victim impact statements. No. All right. All right, Mr. Schmidt, argument and sentencing recommendation.
Thank you, Judge. When a person getting a domestic violence restraining order can be a difficult process. You have to meet a certain burden, you have to go to court, you have to win a hearing. And then once it's achieved, it exists independent of what the parties want to do going forward until they petition the court to change it or get rid of it. A lot of people get domestic abuse restraining orders because they had a domestic incident, like in this case, and then they change their minds, or they come to believe that the way they want to use the domestic abuse restraining order is they want to go back to the person who abused them and then just use it as like a threat in case, you make me mad or something happens. We had a lot of reports here where, at least one of these was the victim showing up at the defendant's house and the defendant calling the cops saying, hey, I want it recorded. I didn't do this. I don't want her here. She's violating her own restraining order. A lot of these were initiated by the victim. We had uncharged ones that were more egregious than that we didn't even bother charging because they're initiated by the victim. And talking with the police in the area, there had been reports of them together at various points in public establishments, together, consensually, of course, not one of them dropping in on another. This was obviously in connection with a divorce that I would guess was probably pretty messy given all these restraining order violations and the arguments associated with them and the fact that there were 3 children involved. The reason why we resolved with 2 of these violations as being the conclusion is the 2 we picked are the 2 where Mr. Ainley violated the restraining order and he admitted to police he violated the restraining order. There was another one that involved his Facebook, which have been quite provable. And then the other 3, 22 CM 143, 23 CM 59, 23 CM 45 would have all required testimony from children between the ages of 8 and 15 at trial to get convictions in a contested proceeding. There are a lot of ways a bad divorce can go, and the worst divorces go in a way that involves the children. And avoiding that, I think, was of great public interest. I think securing it on just 2 convictions is more than enough. I think that the resolution we're asking the court for here today is going to make sure the restraining orders, it can't just be up to Rachel anymore to decide when it's enforced and when it's not. We'll have somebody else there to make sure. It is optimistic that it would appear the victim has a significant other now and that it's been 4 months since the last violation. So I think these are positives that would indicate that hopefully this is done with. So for those reasons, I think it's appropriate in this case. I'd ask the court to follow the agreement. Thank you.
Well, what's the agreement? What is your
Oh, we
recommendation?
didn't articulate it. It is.
Maybe I missed something, but
We were free to argue. So.
Oh, my bad. I thought it was agreement. The state's asking for 1 year probation on this, withheld sentence, court costs. If the court did do a state and imposed sentence, because I know it's been preferring that lately, I would say something towards the lower end. I don't think a ton of jail is necessary for what this is, given the fact pattern I outlined, given that, messy divorce, back and forth, wishy-washiness. This wasn't like, I don't think any of the violations of the restraining order actually involved Mr. Ainley doing anything violent with her, just them being together and then them maybe having an argument and her calling the cops. So for that reason, I think 1 year probation necessary. If there weren't so many violations, I'd probably just be saying costs and let the restraining order fly. But with this many, that just doesn't make sense. So that's what I'm asking for.
Mr. Benson?
Thank you, Your Honor. Obviously, my client's here today pleading guilty and taking responsibility. And Mr. Schmidt is correct that a lot of these were brought on by the victim's behavior in this matter. I think my client would tell you that she still tries to contact him, but not from a number he knows, from private numbers and numbers that don't show up on the phone. Apparently she had a law enforcement contact a few weeks ago. She called him, and it was a particularly bad divorce. And he's not even able to see his own children that he has with her right now. I'm sure you're familiar with that. He is employed at the plastics factory in Frederick, working full-time on the third shift. I say he needs to keep that job so he can pay his child support. He has moved to Polk County. He's a little reticent about giving his updated address, as he doesn't want her to show up at his door again. But should the court order it, he will give his address to the court. It's required, I would imagine.
It is required, unfortunately.
That said, they had a 17-year marriage, and as he told me, it's hard to let go of something like that, and that's understandable. But he did admit twice to law enforcement that he violated the restraining order. Don't necessarily have an objection to Mr. Schmidt's recommendation. I guess we'd just like to see it be a straight fine, and the restraining orders are still in place, Your Honor. Thank you.
Thank you. Mr. Ainley, do you care to make a statement here today? Let me know anything you want me to know.
I just kind of get confused sometimes, how she can call me and crying, and, she calls me all the time from different numbers, and I don't know, what numbers they are. And it kind of confuses me because I feel like I'm the victim here. Her and her two older sons came to a place where I was at on June 3rd, and her two oldest boys attacked me and slammed me on the ground, broke 6 back ribs. So that's kind of why I'm trying to stay away from where she, yeah.
This was in Polk County, Your Honor.
It was in Polk County.
And so there's open criminal cases?
I filed police reports and everything, so it's still under investigation. So, but I mean, and then she'll come to where I live or whatever. And I'll say, "What are you doing here?" I said, "What are you doing here?" She said, "I can come here if I want." I said, "No," and it's like this restraining order just works just against me and not her. She just intimidates me. And, I still love Rachel, I always will. But I had to get away from that mess. Through the years that we were together, I've been to jail, God, I don't know how many times for disorderly conduct, calling and lying and stuff, and I just finally came to an end. I just had enough. But she called me the night before last wanting to know what the payoff is on the property. And I said, "Well, I signed quit claims deed over to you." I said, "That's all on you now." I said, "I don't know what it is, but yeah, she just continues to call me, and most of the time I'm thinking, well, is something wrong with one of my kids or what, So other than that, I wouldn't even communicate with her. I had my children involved, haven't talked to them in over a year.
Thank you, Mr. Ainley. I know that this is difficult, and this is one of the situations. I mean, this is an issue with restraining orders, with injunctions, when it is I do say it's being abused by the victim, by the person who went and sought it and received it. If she's making the contact with you and through different numbers and things that you have no clue of being able to determine if it is her or not her, or someone connected with Ms. Ainley, with Rachel. And I say her name, she is a victim in this case, but this is a 17-year marriage, and I've been on the bench now for 6 years. I was practicing in Burnett County, I don't know how many since before then, doing guardian ad litem work, etc. And I've said this prior to the beginning of your cases, and this isn't the first time you've been in front of me. It's been years and years as a judge. And as a guardian ad litem, I was a guardian ad litem of Ms. Ainley's, a few of her kids with Mr. Erickson. Before you moved, I think it was to Tennessee. I think that's where you moved. So I have been quite familiar with you and Ms. Ainley's relationship, and how tumultuous it has been. Once I took the bench, I don't know how many times somebody, you or she or one, have filed a restraining order, an injunction, and divorce. I don't know how many times it's come in front of the court. You are more than oil and water. You are fire and gasoline. Fire and gasoline. And I don't know how your household at any time was calm. And I'm not saying this to make you feel, to say that you are a terrible person or she's a terrible person. Sometimes people's personalities, they don't coincide. They don't work. And the more you try and force them to work, the more you get situations like this. And it's ridiculous having you come into court time after time, get arrested time after time again for violating restraining order. Some of them I knew from the criminal complaints or whatnot, or things that were said into court, that she was the one that had contacted you initially. And then that's where, it was in the middle of it. I couldn't say, but you're the one who will get in trouble, Mr. Ainley. You are the one who was legally not permitted to have any contact with Rachel, none. And so when she contacts you, you just got to hang it up. And I understand the heartstrings and the pulling of the heartstrings, and she's crying, she needs your help. You've always been what she thought was you were her person, her confidant, the person that helped her. I'm going to say that both of you have held each other down and chained each other to the ground more than you have lifted each other up to be better versions of yourselves. And the saddest thing is it involves children. And now you have, I don't know your entire criminal history, but now you have 2 criminal convictions on your record that say that you don't listen to the law. And so that's going to be difficult, and that's going to carry you through the rest of your life now. If I could restrain her, I would do so. The law, she's not in front of me where I can say, okay, you're going to be legally responsible if you contact Mr. Ainley. You're going to be thrown in jail. You're going to be reprimanded, because it's not in front of me. She's not here. She doesn't have a restraining order or an injunction against her. It's her against you. So you're the one who can't contact her, and you can't reciprocate. So if she calls you, you have to hang up. You just have to hang up. Sounds cold, because especially if you're saying 17-year marriage and there was a relationship before there, and there's such a connection, and you feel like you may hate her at times, but you'll love her too. And that's the hard thing, and that's the struggle. It's not cold to hang up on her. Not cold, even if she's crying and begging and saying, Tim, I need your help. I'm so alone. I'm broken. Whatever she's saying to you to pull at those strings, it's not cold to say goodbye, Rachel, and to hang up, because in the end, look at what's happened. Then you don't go along and you don't do all of the things on her terms, doing the things that she wants, how she wants them. And then you get into an argument, and then it's instantly 911. Okay, he's violating the restraining order, the injunction. Come get him. So all it's going to do is continue to cause you turmoil and angst. And again, not just you, your children know all of these things, no matter if you think they don't, or she thinks they don't, they do, they know all of these things. And it is traumatizing them.
Yes.
And they will not be the same individuals or the same people that they were born into this world to be, because they've had this on their shoulders. And they're not only trying to grow up and become good adults, but they're raising their parents, because they're in the middle of it. So as hard as it is for you, Mr. Ainley, as hard as it is for you, if she calls you up and she begs or cries or pleads or says, I want you back, I've changed this time, I've changed, click. People won't change in a matter of 18 years in the course of 4 months. Things don't change. Things don't get better that quickly. Someday, I don't know. I'm not God. I'm not a crystal ball. I don't know. But all it's doing is bringing you down, Mr. Ainley. I don't know. I don't know with the fact patterns here, because even the state is saying that predominantly or most or all of these were initiated by the victim. That's what makes this the most difficult. You knew you couldn't, you knew you shouldn't, but you did. So I guess it's the law is here to get it into your head that you can't. You just have to say no and figure everything else out. And now that she has a significant other, I don't know how that's going to go. That's going to come in and she's going to try and do more, but you can't. You can't. You have to say no. Okay, well, probation is probably appropriate. I think these are 4-year injunctions. I take judicial notice of them, at least the one involving Ms. Ainley. I believe they're 4-year.
The restraining order,
Yeah,
I think on the 3 younger children, it's 2 years.
I think on
And
hers
then
it's
for
4.
Rachel and Logan, it's 4 or 5 years, I think.
So I guess what I'm gonna do is I will put you on probation. I'll follow that recommendation for 1 year. With the ability to discharge early after 6 months if there's no further violations. The condition is, it's simple. No contact with Ms. Ainley. Follow the injunction, follow that requirement, no contact. And no contact means no contact. She's crying, she's complaining, she's crying, she's complaining, she's saying all of these things. You just gotta hang up. And I don't know what's going on in Polk County, just for the record, just because you said it, I was gonna take judicial notice. I can't find anything, at least involving Ms. Ainley. So I don't know if it involves the children, if they're being charged or whatnot, but I find nothing in Polk County,
I think it was 2 older children that aren't his.
like in
were-
Erickson. I don't even know their names right now, but you gotta avoid them too. I don't know how to, I mean, if you file your own, you can file your own injunctions. You can file your own TROs, temporary restraining orders. If that's gonna be, what's good for the goose is good for the gander. And if she's gonna violate, she's gonna harass you by getting you to have contact with her, perhaps the accountability should be the same. But that's up to you and Mr. Benson to have those discussions and where you want to go with that. So 1 year probation, you can discharge early after 6 months. What I'm gonna do is, I don't want to do a withheld sentence. There's never in a million years, I'm gonna do 9 months each on these 2 counts anyway. There needs to be a penalty because you know your restrictions, you know what you need to follow, and you still didn't, be it because of the heart or whatever. But what I'm gonna do is for 22 CM 189, I'm going to do an imposed in state jail sentence, 30 days. And for 22 CM 190, I'm gonna do imposed in state jail, 30 days. They will be consecutive, so it'll be a total of 60 days. So if you violate, you could sit for a total of 60 days. It's still, jail's not fun, Mr. Ainley.
Been there, I don't like it.
Nope. So you don't want to go sit for 60 days.
No.
So if she calls you, she's crying, she's saying how much she misses you, she needs you, she loves you, she's hurting. You're the only person that can understand. You're the only person that can fix anything. Fix it. Help, help, help. Click. Hard, it's painful, click. Okay. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. With regards to fines and fees, I think he is 500 posted. That's all that's showing on my system anyway. Okay, she's gonna quick check and see, because mine only pulls up 500.
Just up the highway on the right.
Yes. 15, 22 CM 143. 522 CM.
Well, that's the one I'm seeing is the 190, but okay. All right, so, and did he retain you privately, Mr. Benson?
Yes.
Okay, so I don't have to worry about attorney's fees or whatnot. All right, so $443 in fines and fees for each of the counts. Well, no, for one of the counts. For the other count, I'll only do the DNA search charge of $200. You have enough there to cover it. The rest of the money will be remitted back to you.